Good. You're long life. Continuing from what, good evening to all of you. Continuing from where we left yesterday, I was discussing the law of sales contained from section 54 to 57. It's a very small chapter. First, sale is defined as where there's a transfer of ownership from a person called the seller to a person called the purchaser for a consideration called the price. It is called a sale. And the person selling the property is called the seller, and the person to whom it is sold is called the purchaser, or the vendor and the vendee. And every contract has to have consideration. That is the reason the seller parts with his ownership of his property in exchange of the money which he receives from the purchaser towards the purchase money. And this transaction is called a sale. And as far as a sale is concerned, every sale of the value of 100 and above has to be in writing and has to be duly registered. Then how a sale deed is drafted is, first and foremost is the date on which the sale deed is drafted. This deed of sale executed at Hyderabad on this the day of so and so by so and so, that is Mr. A, son of so and so, hereinafter called the vendor, which term shall include all his heirs, assigns, and legal representatives in favor of Mr. B, son of so and so, age so and so, occupation so and so, resident of so and so. Then the next para starts, whereby you say that whereas the vendor is the sole and absolute owner and possessor of house number so and so, admeasuring so and so square yards, comprising of a double-storied building situated at so and so Hyderabad, by virtue of having purchased the same through a registered sale deed from so and so, bearing document number so and so. Next paragraph. Whereas the vendor's vendor, he was the owner and possessor of house number so and so, clearly mentioned in the schedule, by virtue of having purchased the same from its previous owner through a registered sale deed bearing document number so and so. Next para is, whereas the vendor has offered to sell his property for his domestic necessities to the to the vendee for a total sale consideration of rupees so and so. Next para, whereas the vendee has accepted the offer of the vendor and agreed to purchase the schedule mentioned property for a total sale consideration of rupees so and so. Next para, whereas the vendee has this day paid the vendor a sum of rupees 10 lakhs as advance and earnest money, the receipt of which is admitted and acknowledged by the vendor, and agrees to pay the balance of the sale consideration within 6 months from the date of this agreement. Next para. Whereas the vendor hereby admits and acknowledges receipt of the advance and earnest money of rupees so and so from the purchaser or the vending, and agrees to receive the balance of the sale consideration within 6 months from the date of this agreement. Next para. Whereas if the plot is agreed to be sold, you say that whereas the vendor has agreed and undertaken to get the land surveyed and to localize and identify the plot agreed to be sold to the purchaser, and execute and register the sale deed in favor of the vendee on the accomplishment of the purpose. Now this agreement, now the sale deed witnesses as follows: one, that the vendor hereby sells, conveys, transfers all his right, title, and interest in respect of house number so and so, so and so, so and so, situated at so and so, to the vendee, together with all easements and appurtenances attached thereto, for a total sale consideration of rupees so and so. Why I am using the word easement is not a right owned by the or possessed by the vendor, but by long usage for 20 years period, you get a right of ingress, egress, then you get the right of light, air, ventilation, sanitation, also the right of what is called using the bund to reach your agricultural property, and also the place of worship where you go every year to celebrate Bonalu or other festivals. And then these are all called a right which you enjoy over your neighbor's property for a 20 years period, where you acquire a prescriptive right, or it is called an easementary right. And this is also called in the Transfer of Property Act language as servient heritage. And also the appurtenances. What do you mean by appurtenances? That means the doors, windows, motor, which is used for pumping water, then the borewell, then the electrical connections, doors, windows, and then the other fittings, which are the fans, air conditioners, etc., which are existing. As far as the property is concerned, it is called appurtenances. Then everything is transferred, not only the dominant heritage, that the proprietorship, as well as the possessory right, as well as the easements and appurtenances are passed on to the vendee by the vendor. Then second one is the vendor hereby declares vendee hereby accepts to purchase the schedule mentioned property of the belonging to the vendor for a total sale consideration of rupees so and so. Then third one is the vendor has already paid the vendee has already paid the vendor a sum of rupees 10 lakhs as advance and earnest money, and is paying the balance of the sale consideration through a demand draft number so and so, dated so and so, drawn on SBI Nacharam branch, and the receipt of which is admitted and acknowledged by the vendor. Third one is the vendor hereby declares that the schedule mentioned property is free from all encumbrances, rival claims, charges, etc., and agrees to indemnify and keep indemnified the vendee against any future losses in case of any defective title. Then the fourth one is the vendor hereby declares that he is the sole and absolute owner of the schedule mentioned property, and no person apart from him, including his legal heads, have any manner of right, title, or interest thereon. Then next paragraph, sir. The next one is the vendor further declare vendor as this day vendor as this day delivered vacant possession of the schedule mentioned property to the vendor, the receipt of which is admitted and acknowledged by the vendee. Next para is the vendor has this day handed over all the linked documents pertaining to the schedule mentioned property to the vendor to the vendee, and the receipt of which is admitted and acknowledged by the vendee. Next one is the vendor hereby declares that he has paid all the taxes and the charges in respect of the schedule mentioned property up to the date of registration, and the vendee shall be liable or responsible to pay the taxes as well as the necessary charges immediately on the execution and registration of the sale deed. Next one is the vendor hereby agrees and undertakes to cooperate with the vendee to get the mutation and other purposes required by executing affidavits and letters required whatsoever. Then last one is in witness whereof the vendor has set his hand and affixed his signature voluntarily without any compulsion or force, and in a sound disposing state of mind. The vendor signs and the vendee also signs, and it is attested by two witnesses. And the schedule of the property which is sold through the sale deed is clearly mentioned, giving the description with the boundaries. The precautions which you have to take as far as sales transactions are concerned is embodied in section 55. It says it is a duty of the vendor to hand over all the liquor documents to the vendee for inspection before purchase of the property. Next one is the vendor has to pay the taxes and other charges up to the date of registration. Third one is the vendor has to attend to the repairs or renovations as far as the property is concerned before it is sold to the vendee. And fourth one is the question is whatever questions are asked by the vendor, the documents should be made available to the vendee for inspection. Then next one is suppose there is any charge over the property, suppose any housing loan is taken, bank loan is taken, the particulars of the bank loan or the particulars of the housing loan has to be mentioned in the document itself, and it should be made clear that the vendee has to discharge those outstandings subject to the amount payable to the balance of the sale consideration being adjusted towards that. So whatever are the duties of the seller also becomes the rights of the buyer. Buyer is entitled to quiet and peaceful possession. Buyer is entitled to uninterrupted possession. Buyer is entitled to get all the documents which are required for the purpose of inspection before entering into the transaction, and also any latent or patent defects in the property has to be disclosed by the seller to the purchaser. But one thing, please remember, there's a doctrine called doctrine of caveat emptor, that is, buyer beware. As far as the buyer is concerned, he must enter into the transaction after thorough inspection of all the documents and also preferably give a paper publication that he is intending to purchase the property, and any person having any manner of right, title, or interest should intimate him so that the title is clear. So these are all the rights and duties of the seller and the purchaser. Please remember, it's only of academic value, but for the purpose of being laid down in the sales, I have to discuss it. Then we go to the next section 56, which deals about marshalling of purchase. Here's, let us say, two properties are there. One property, both the properties are mortgaged to 1A. Then let us say one of the properties B is sold to one of the properties Y is sold to B. Then B can ask A, look, you satisfy your debt from out of the property which is not sold to me. And then if any shortfall is there, you proceed against my property. And when this right is exercised, it is called marshalling. Then next section is, suppose there are any encumbrances in respect of the property and a decree has been passed for sale of the property, it gives a right to the purchaser to discharge that encumbrance, and with the permission of the court, he can deposit the the consideration amount or the decretal amount into court, and with prior notice to the encumbrancer or the person entitled to that amount. So that finishes the chapter called sales. But here you have to, one thing you have to remember, there is a distinction to be made between a sale and an agreement of sale. Here, sale is, it's a concluded contract or an executed contract between the seller and the purchaser. There's nothing else to be done. But as far as agreement of sale is concerned, it is supposed to be an executory contract. Some of the obligations are performed, and the rest of the obligations have to be performed at a later date. Here, the wording is very important, sir. In the agreement of sale, you say the vendee hereby agrees to purchase. You don't say in sale, you say vendee has this day purchased. That means it's a past tense. But here in agreement of sale, you say you want to purchase, you are purchasing it, vendee agrees to purchase. So the word agrees is important. So here in sale deed, we mention the word the seller hereby sells, conveys. That means it's a fait accompli. It is an accomplished fact, and the question of agreement goes out of the question. Then in the agreement itself, you specify so many things. The same thing like a sale deed, except it is an executory contract where some of the obligations are performed and the rest of the obligations have to be performed at a later date. But please remember, don't forget to write the schedule of property in every document, because it gives the description of the property, which is subject matter of the contract interest either parties. So this finishes the chapter on sales. So the Transfer of Property Act, in all respects, I've covered, of course, within a short time of 10 days. But still, it's not, though not exhaustive, the broad outlines of the transfer of property I've discussed. But here, there are some people who have joined later from other states like Karnataka, etc. For the benefit of them, I will just revise the stages of a civil suit. As far as the stages of a civil suit is concerned, first and foremost, you must know what is a civil suit. Here in Urdu, we call it as Diwani, Diwani Dawa. Diwani means civil, Fauzdari means criminal. Here, as far as civil suit is concerned, it is initiated by a person for espousing or for getting his grievance redressed as far as a civil dispute is concerned. And it is initiated either by the individual, either by the company, either by the firm, either by the association of persons, or either by a partnership firm. Anyone can initiate it. When you enter into a contract, you must have two or more persons required. So you cannot file a suit against yourself. You have to file it against the other side. The person who initiates civil proceedings and brings out his grievances to the civil court is called a plaintiff, or in Telugu we call him as Vadi. Then, as far as the suit is concerned, we file it against the opposite person or persons. They are called the Prativadi, or they are called their defendants. Plaintiff is a person who initiates a civil proceeding is called a plaintiff, and the person against whom it is initiated is called the defendant. And the proceeding which you initiate in a civil court is what is called a suit. Then, as far as the provisions are concerned, sir, we have got about 50, 52 to 53 orders, and we have got about 54 sections. But of course, it's not. I've already discussed all of them in detail, but I'll give just the stages of a civil proceeding. First and foremost is all plaints are filed under the provisions of Section 26, read with Order 7, Rule 1. All plaints are filed under Section 26, read with Order 7, Rule 1, CPC. And then here, before going to the suit, we must know the jurisdiction of the courts. As far as the courts in every state is concerned, is divided into two parts. One is called the higher judiciary, and another is called the district judiciary. As far as the higher judiciary is concerned, it is the highest forum as far as the state is concerned. That is your high court. But as far as this district judiciary is concerned, previously it was called subordinate judiciary, but now it is called district judiciary. It is a three-tier compartment. You have got at the fulcrum, you have got the principal district judge assisted by additional district judges. Then below them, you have got the senior civil judge or additional senior civil judges. And then below them, you have got the junior civil judge, principal junior civil judge, or additional junior civil judges. Here, jurisdiction is of three types because before going to the plaint, I'll discuss that. Here, one is pecuniary jurisdiction, another is territorial jurisdiction, and another is subject matter jurisdiction. This is dealt with by the CPC from section 16 to 20 of CPC. Here, section 16 says that pecuniary jurisdiction. What do you mean by pecuniary jurisdiction? That is, according to the value of your suit, which you value, the jurisdiction of the court is fixed. Please remember, we pronounce jurisdiction as one word. It is not one word, sir. It is two words. Jurisdiction. Juris means courts. Diction means authority. Authority of the court to entertain a particular matter is called jurisdiction. As far as pecuniary jurisdiction is concerned, even in Karnataka, you have got what is called the city civil courts. I think the Karnataka civil courts located in Kempagoda Circle are called city civil courts, Karnataka at Bangalore. Here, as far as city civil courts are concerned, they are governed by an enactment called the City Civil Courts Act. They are governed by City Civil Courts Act. But as far as the courts in the Mofussil are concerned or the districts are concerned, they are governed by the Civil Courts Act. And please remember, jurisdiction, pecuniary jurisdiction varies from state to state. As far as our state is concerned, either you call it Telangana or Andhra. Here, the jurisdiction of the junior civil court is all suits of the value of not more than 20 lakhs. The jurisdiction lies to a junior civil court. Then from 20 lakhs 1 to 50 lakhs, the jurisdiction lies to the senior civil court. And from 50 lakhs 1 unlimited, the district court has got jurisdiction. But here, recently, what they have done is to lessen the burden of the junior civil courts, they have reduced the pecuniary value from 20 lakhs to 10 lakhs. And the junior civil court here in Telangana, they have got jurisdiction only up to 10 lakhs. Above 10 lakhs, you have to go to the sub court or what is called the senior civil court, which can hear matters up to 50 lakhs. And above 50 lakhs, it has to go to the High Court. But please bear one thing in mind. Why these amendments have been brought about is that to see that the High Court, as they say, the High Court can only decide matters regarding the interpretation of the Constitution and they are not bothered about the civil appeals. That's the reason slowly they are washing off their hands as far as civil jurisdiction is concerned. But still, invariably, here in Telangana, if the value of the decree is more than 35 lakhs, it goes to the High Court. But till 50 lakhs, district courts have got jurisdiction. And I'm sorry, senior courts have got jurisdiction. And from 50 lakhs, one unlimited, district courts have got jurisdiction. And why this has been done is to see that the people at the grassroots level, people who are practicing in the Mofussil area, they can stick on to the same court. They need not come to the city, commute to the city and file appeals. And please remember, everyone is strong in their own area. And that is the reason why the amendments have taken place. So, pecuniary jurisdiction or the money value jurisdiction is not static at any time. I still remember when I started practice in 1972, the jurisdiction of a civil court was only 5,000, and above 5,000 to 20,000, it was the sub court, and above 20,000, it was the district court. But now things have changed. Things have changed because not that the money value has increased, money value has got depreciated. And now, the as per the directions of the Supreme Court, when we have mandals, previously we used to have talukas. Talukas, the basic population was 2 lakhs, but the talukas were broken into 4 fragments called mandals. That is, for every taluka, you have got 4 mandals. Mandals means a population of 50,000. So the Supreme Court direction is the justice should be available at the doorstep of a litigant, and that is the reason for every 2 mandals you have got one municipal court, at least a junior court is constituted. And then, as far as the districts are also concerned, the same jurisdiction proposition applies. Then we go to the territorial jurisdiction. Territorial jurisdiction is where the cause of action is accrued, where the cause of action is arisen, where the property is located, where the document has been executed, where the right to sue has been initiated. That court alone has got jurisdiction. Suppose, let us say, you are at Hyderabad, but you are trying to enforce a charge over immobile property in the case of a mortgage. Then, wherever the property, suppose it is located at Nalgonda, you cannot file a suit in Hyderabad. You will have to file the suit at Nalgonda, whichever court has got jurisdiction. Why? Because it's easier to enforce it. But previously, we used to have sections to say precept. Section 46. Section 46 used to say that even if the property is located outside the jurisdiction of the court here can address a letter of request to that court to execute the order passed by this court, and a letter of request is sent to that court, and that court performs the ministerial functions of executing an order passed by another court. So now, of course, precepts have almost gone out of vogue. It is not being implemented today. But here, the question is territorial jurisdiction is where the subject matter is located, where the cause of action is accrued, where the document has been executed, which is the court, which is the district, or which is the official, within which that particular property comes. The suit has to be filed in that particular area only. That is called territorial jurisdiction. Then we go to what is called subject matter jurisdiction. Subject matter jurisdiction means we are now in an era of what is called tribunals being constituted. Rent Control Act, you have got the rent controllers. Then, as far as Excise Act is concerned, you have got the Excise and Customs Code. Then, Value Added Tax is concerned, you have got the VAT Tribunal. Then, as far as income tax matters are concerned, you have got the income tax ITOs, and then what is called the Income Tax Appellate Tribunal. As far as commercial taxes are concerned, you've got the Sales Tax Appellate Tribunal. Then, as far as trade unions and labor disputes are concerned, you've got the Industrial Tribunal. Then, as far as chit funds are concerned, you've got the arbitration procedure where the arbitration lies to the registrar. If it's a matter arising out of a cooperative society, the registrar of societies is entitled to hear the matter, and the appeal lies to the cooperative tribunal. And like that, and especially family matters, all the matters arising out of a family, that is what is called Special Marriage Act, Hindu Marriage Act, Indian Divorce Act, Parsis Marriage Act, so on and so forth. And what concerns a family, only the family court can hear those matters. And in family court, an advocate is not given a direct entry, but he can file an application under Section 13 of the Family Courts Act, saying that the party gives the affidavit, sir, I'm not versed with legal matters. I want the assistance of a legal counsel who can assist me as far as conducting the case is concerned. Then permission is normally granted. And all petitions that are filed before the family court is signed by the party and mostly not by the advocates. And please remember, unless the permission is granted to you under Section 13 of the Family Courts Act, you cannot appear directly. And that's why you appear there only as an amicus curiae, that is a friend of the court. So when so many tribunals are constituted, slowly the jurisdiction of a civil court is boosted. If you are aware, there is one section in the CPC called Section 9 All matters of civil nature can be filed in a civil court except those expressly barred. That is, these are all the matters where the civil court cannot entertain the case. Then, with this background in view, we go to how a case is initiated in a civil court. The first stage is filing a document into the court called a plaint, or what is called manuvu. In Telugu, it is called manuvu, and I think Kannada, I think it must be manuva or something like that. Then in Tamil, it is called pradu. Pradu means litigation or a suit. Then, as far as a plaint is concerned, it's a document filed into the court by a person called the plaintiff. And first and foremost it is filed under Order 7, Rule 1 and 2, read with Section 26 CPC. Whichever court it may be, according to the jurisdiction, you describe the court. Then all suits of civil nature on the original side are numbered as OS number, or whichever year it may be. Then between name of the plaintiff, description, is where the person who initiates the suit is called the plaintiff, and the person against whom it is initiated is called the defendant. And then after that, beneath it, you mention what is called suit for claim for rupees so and so due under the promissory note. You underline that. Then the plaintiff above name begs to state as follows: first, name, address, and description of the plaintiff; name, address, and description of the defendant. Third one is address for service. If you are the advocate, your address is given with email and your cell number also. And the address for service on the defendant also you give, say, same as given above in the cause title. And the next paragraph, you say brief facts of the case: 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, whatever it is. Then you mention it. Then after that, most important provision is cause of action. When you have got a right of filing a suit against the other side, what date it has accrued to you, what are the documents which support your case, and what is the notice you have given, what is the response to your notice which is given, that is called cause of action. Then after that, the next paragraph will be the jurisdiction of the court. This court has got jurisdiction to try the suit as the suit scheduled property is located at Chikbalapur within the jurisdiction of this court. Then next para will be the suit is valued for the purpose of court fee and jurisdiction at rupees whatever money it is, and a court fee of rupees dash is paid under in Telangana and Andhra. It is Article 1B and C read with Schedule 1. I do not know what is the provision in Karnataka, but there the question is you value it according to it and pay the court fee according to the ad valorem court fee that is provided under the schedule. Then after that, you say that the suit is within time and within the period of limitation. And if it is within limitation, you say why it is within limitation, how it is within limitation. And next one is you give a declaration that no suit is filed in respect of the same claim, nor any suit is pending in any court. The last paragraph is the most important paragraph, which talks about prayer, what you want from the court. The plaintiff therefore prays for judgment and decree against the defendants jointly and severally for A, for recovery of rupees so and so due and payable by the defendant towards the promissory note with interest at 24% per annum from date of suit till date of realization. And B is cost of the suit. And then the plaintiff signs, the counsel signs, and then the plaint is also verified, saying that the facts mentioned above are true and correct. And then the list of documents which you file along with the suit, you mention list 1, 2, 3, and 4, and then the party signs. If it is relating to immovable property, you give the schedule of property, and then the party also signs and is verified at the place where the suit is filed. And of course, the docket also is made. And always under Order 6, Rule 1, you have to file the plaint in duplicate, and one copy extra you have to give for the computer, that is for scanning purposes. And then along with that, also file what is called an affidavit under Order 6, Rule 15, bracket 4. That is what is called verification affidavit. Please remember, in this regard, I try to explain it by saying, sir, normally when a client is in a peculiar position, he tries to expose the advocate. He is asked a question whether these averments you have made on your own accord, or is it an advocate who has made the averments. He says, sir, I do not know anything. My advocate has written it. I am not aware of it. So an advocate gets into trouble more particularly when defamatory allegations are made against the party, opposite party. So be very, very careful. That is the reason Why order 6, rule 15 bracket 4 is provided, whereby it is said verification affidavit. The party says that the plaintiff has been drafted as per my instructions, and the amendments made therein are made by me with full restraint and responsibility. And as per the instruction, the plaintiff has been drafted, he signs. Then, along with that, you also file a petition under Order 6, Rule 14 to say that you give in the form of an affidavit saying that the addresses are given, plaintiff's address and defendant's address, and the party says the addresses mentioned above is true and correct, and he signs it. Then, when you file a suit in respect of immovable property, then you will have to file a form called Form 8 under the Civil Rules of Practice, which gives you the description of the property, the value of the property which is valued, and the court fee which is paid, and the party signs. And along with that, you also file what is called the BATA, or what is called the process. Process is filed under Form 61. That is what is Form 61 of the Civil Rules of Practice, where you want the summons to go. Then, if any IA is there, where you ask for interim orders or any order, then you also pay the BATA. And as far as suit is concerned, you have to pay first and foremost is you must pay through court and registered courts. And along with that, you will have to attach what is called summons for settlement of issues under Order 5 CPC. Small forms are there. You will have to fill it up, and then also provide what is called a registered cover with acknowledgement, with the addresses filled in, and the postal stamps affixed, and the stamps also affixed on the process form, whatever is the process fee leviable, you have to pay, and the extra copies of the plaint as well as the petitions and the material papers which you rely upon, the list of documents which you file it under under Form 51, you will have to furnish extra copies of the documents to be provided to the other side. This is how a plaint is drafted in a civil suit. It may be any suit, sir, but this is the procedure you have to follow. But as far as mortgage suits are concerned, the only difference is mortgage suits are filed not under Order 7, Rule 1 and 2. It is filed under the provisions of Order 34, Civil Procedure Code, which provides a suits of special nature that is called mortgage suits. One paragraph has to be devoted to the particulars of the mortgage, name of the mortgage or name of the mortgage, amount of loan, then the documents deposited, then next one is description of the property offered as security, primary documents taken, whatever the primary documents, the collateral security, you give the description, then amount paid, then interest charged, and then the amount actually due, you mentioned. And the last paragraph, especially the play or this cause of action, you say cause of action for the suit arose, and also further secured collaterally through deposit of title deeds pertaining to the suit scheduled property by way of mortgage. So here, why do you mention it, sir? If you don't mention the mortgage, then what would happen is later on you cannot file a suit based on that particular property that has been offered as security. And in the prayer clause, what you write is, you say the plaintiff therefore prays for a judgment and decree against the defendants jointly and severally as follows. 1. A, for payment of rupees so and so. B, in default thereof, for a decree for foreclosure and sale of the charged property belonging to the mortgager. And then please remember, here as far as mortgage suits are concerned, no installment decree can be passed. Even if an installment decree is passed, it's a nullity. So at the most what happens is equity of redemption is granted. The debtor is given the time to pay the principal, interest and cost of the suit, and on payment all the securities had and received by the mortgagee will have to be returned back. And first and foremost, in a mortgage suit, a preliminary decree is passed, then alone the question is the plaintiff will, the defendant will be given an opportunity to pay the money, and only on his non-pay the property will be proceeded against. So this is as far as a mortgage suit is concerned. Like that, you have got various types of suits where two decrees are passed. I don't want to repeat them, but here this is how the plaintiff is filed. Then if you file a suit for specific performance, the question is the prayer clause is very important. To direct the defendant for a decree, a judgment and decree for specific performance, directing the defendant to execute and register the sale deed in respect of the suit scheduled property, and on default thereof, the court to execute the sale deed on behalf of the defendant in favor of the plaintiff and for cost of the suit. This is as plaint is filed. Then next one is how a written statement is filed. Every allegation that is made in the plaint Normally, there are various styles of drafting. First, everything is denied. But please remember, a mere denial, a vague denial, an ambiguous denial, or an imaginary denial will not take you anywhere. But what your defense is, how you want to defend the suit, or what are your strong points, you will have to highlight it by giving out your case. Then the true facts of the case are, then you come up with your case. And please remember, you can, if any adjustment is to be there, you have paid any money which has not been given credit of, then you can ask for a set off. You can ask for an adjustment instead of filing a suit. Then suppose, let us say, you have to receive more amount than the plaintiff, then you can set up a counterclaim. So this is how, and written statement also under the new amendment, it has to be filed under Order 8, Rule 1 within 30 days from the date of service of summons, and maximum period for which it can be extended from time to time under rule is 90 days. And beyond 90 days, the court has got no power to extend the time. But there have been judgments of the Supreme Court reported in 2004 Supreme Court, 2005 Supreme Court to say that this 90 days period is not mandatory as far as lower courts are concerned, except the commercial courts. The next one is issues. I'm sorry, summons. That is, once the plaint is filed into the court, it is checked, it is numbered, and then summons are issued to the opposite side. There are 4 or 5 modes of service. One is summons through court, another is by registered post, another is by personal delivery, and now the CPC has been amended. It can be sent by WhatsApp, it can be sent by speed post, it can be sent by courier, or any other speedier mode of service to the opposite side. And whenever summons are served on the other side, copies of the papers have to be enclosed along with the process. Without that, it is not proper. Then the next stage I told you, written statement. Then after that, you have got what is called the issues. What are the points on which the parties are differing? What are the points the court has to decide? They frame it in the form of a questionnaire, and based on that, oral and documentary evidence has to be led. And now CPC has been amended in 2002, where they say all evidences in chief shall be filed only by an affidavit. And as far as marking documents are concerned, court marks the document and then records the cross-examination by itself, or delegates it to an advocate commissioner to record the cross-examination and file the report into the court. And then the next stage is reached where the arguments are heard on both sides. And now a provision also has been made in the CPC by amendment, where Order 18, Rule 2, Bracket 3 has been introduced, whereby you can file written arguments into the court, spelling out your arguments. And then some restricted time is given to you where you can submit oral arguments. Then the next stage is reached. Judgment is passed after hearing arguments of both sides, and it has normally it is passed on the same day or within. Previously, it was within 14 days. It has to be passed if it is reserved. Then slowly it was extended to 30 days. Now the present position is within 60 days. At any time, the judgment can be passed. But usually, what happens is the courts take its own time in passing a judgment. Then the sum and substance of the judgment is what is called a decree. Decree, normally what is executed in a civil court is only the decree. Judgment is of no consequence. And how you get the fruits of the decree, fruits of the litigation is by executing it. Executing what? Executing the decree. Decree can be defined this way in an objective way. Suppose you go to a sugarcane dealer, order for a fruit juice, then that person, what he does is he crushes the cane and then takes out the juice. Then he puts a filter and then filters the juice. The residue remain on top and the filtrate comes down, and what you consume is the filtrate or the clear solution. The clear solution is called the decree, and decree is alone executed in a civil court and not the judgment. Judgment is of academic value, but decree is one which is the basis of the litigation which you have initiated. Then the next stage is you've got the execution procedure. That is the lengthiest chapter in the entire CPC. That is Order 21. Order 21 says the methodology through which you execute a decree passed by a civil court is called execution. There are 5 modes of execution. One is what is called attachment of salary. Next one is attachment and sale of movable property, attachment and sale of immovable property. Fourth one is arrest and detention in civil prison. And fifth one is what is called receivers. Then The execution petition is filed under Form 11. And Form 11, you got what is called Form 11 or Form 7, somewhere around that. Here it is filed under the provisions of Order 21. First, the name of the court, then the EP number. All execution petitions are numbered as EP in whichever suit, name of the decree holder, the person who has obtained the decree, name of the judgment debtor against whom the decree is passed, and then particulars of the decree, that is name of the decree holder, name of the judgment debtor, then date of decree, amount decreed, then afterwards court cost awarded, interest awarded, a calculation of interest, and then after that you come to the amount and less paid, whatever amount has been paid, then you say total amount due, then against whom you want to execute it, against the JD or against JDs, then against to issue a warrant of attachment of salary or so and so under this provision, and then the decree holder signs, and behind it you fill up the schedule if you ask the particular relief, and that's only. And along with the execution petition, you are also supposed to file a copy of the decree and a certificate of non-satisfaction that the decree has not been satisfied. Then normally, if the decree is within 2 years, no need of any notice to the other side. But now, according to the High Court circular, notice has to be compulsory given to the other side, and other side has to be given an opportunity of filing the counter and also contesting the execution petition. I think with this small revision, for the benefit of those who have joined recently, I've just repeated it, not in exhaustively, but in a nutshell. The other provisions are also there, which I shall discuss tomorrow. That is appeals, etc. Now the interaction period starts.
Sir, good evening, sir.
Good evening. Yes, Mr. Prasad.
Yes, sir. Kindly elaborate once again on the difference between judgment and decree, sir.
Sir, the judgment is the sum and substance of the entire case based on issues, findings given vis-a-vis the evidence recorded, the contradictions, admissions, inconsistencies, etc. That's the final verdict. But decree is one which is a sum and substance of the judgment. Suppose, let us say, a judgment is passed saying that you as a defendant is liable to pay 50,000 rupees. So this court doth order and decree that the defendant pay to the plaintiff a sum of rupees 50,000, and the defendant also pay to the plaintiff interest at 24% of 50,000 from date of suit till date of realization. Then future interest at 6% from date of decree till date of realization. Decree is sum and substance of the judgment. What is executed in a civil court is a decree. Judgment is not executed. Please bear that in mind. That's the reason if you see the Order 21, it said execution of decrees. It's not execution of judgments. Judgment is the final verdict that is given. But who has to pay whom, what is the interest liable to be paid, what is the cost liable to be paid, what are the reliefs that the parties are entitled to be in the form of a small paragraph. So that is a decree. Are you able to follow, sir?
Yes, sir. So after the judgment, what is the process, sir?
After the judgment, you are given 7 days time to file the fees certificate and your memo of cost. Then after seeing that, the decree is prepared by the section and the decree is signed by the court. Copy of the decree is given to you, and you can file an execution petition based on the decree. Whatever is the contents of the decree, you can mention it and then execute it accordingly, sir. Judgment is not executed. Judgment is only for your academic value, as far as the final verdict of the case is concerned. But decree is one which you execute it in a civil court to reap the fruits of the litigation which you have initiated against the opposite side. Am I making myself clear to Mr. Prasad?
Yes, sir. Thank you. One more question, sir. So you said there are 5 types of execution petitions, sir?
Yes, and not execution, but the modes of execution. That is attachment of salary. That is Order 21, Rule 48. Then you have got attachment and sale of movable property. That is Order 21, Rule 43. Then attachment and sale of immovable property. That is Order 21, Rule 54. Fourth is arrest and detention in civil prison. That is Order 21, Rule 37 and 38. And receivers is the miscellaneous. That's Order 21, Rule 40 or something like
that. Sir, what is the last one, sir?
Receivers. An officer of the court can be appointed to collect the rents, collect the profits, collect the income, and deposit the rents or the income from time to time and maintain proper accounts and then deposit it every quarter or every month as the directions of the court, and to be appropriated towards the decree. Am I making myself clear to you? Please, it's very, very rare, sir.
Okay, sir. Yeah, thank you, sir.
Right. Mr. Chamarthi.
Sir, with regarding the attachment of salary, is there any limitation that
Sir, as far as attachment of salary is concerned, it is subject to Section 60. Section 60 says what are the properties that cannot be attached. One is a salary of a person up to 1,000 rupees is exempted, and above 1,000, 2/3 is exempted, and what is attachable is only 1/3. But there are certain other things, that is the property of a farmer, property dwelling house of a farmer, tools of artisans or house of artisans, stipends or pensions paid to the persons concerned. All these things under Section 60 cannot be attached.
Sir, with regarding to amount, sir, that amount was sent to the court only 24 months, sir. Is there any limitation that only 24 months is the attachment is?
It depends on the order passed by the court. Suppose the court says attach it for 24 months. Again, nothing prevents you from asking for fresh attachment. You can file another if you have any number of VPs, you can file within 12 years, sir.
Okay, sir. Okay, sir. Okay, sir. Thank you.
నమస్కారం సార్.
నమస్కారం
సార్ నేను వెంకటరెడ్డి సార్. ఇది వన్ కేసులో ప్లెయింటిఫ్ డిఫెండెంట్ నెంబర్ 2 చనిపోయినాక కేసు వేసింది సార్. డిఫెండెంట్ నెంబర్ వస్తుంది కానీ డిఫెండెంట్ ఎర్లియర్ చనిపోయింది సార్. సూట్ మెయింటైనబుల్ సార్.
సో ఇట్ ఇస్ ఫైల్డ్ అగైన్స్ ఎ డెడ్ పర్సన్. If it's filed against a dead person, as far as that person is concerned, the suit will go. It abates.
Entire suit will be dismissed, sir.
It has to be dismissed as against only that person.
Okay, only one person.
Exactly. I face the same situation, sir. In one case, a suit was filed in 2014 end. The person died in 2008, and it was filed after 6 years. The defense taken by the other side was he did not know that the defendant died. He inquired from the process server who told him that the defendant died. Unfortunately, what happened was he served the summons of the wife of the deceased. And then I filed a petition for rejection of the plaint, saying that suit is filed against the dead person. Suit is not maintainable. Right?
Sir, entire suit will be
suit will go. Suit will go. Suit has to go rather.
అదేంటంటే సార్, ఐఎమ్ ది పార్టీన్ పర్సన్ ఇన్ దట్ కేస్. ఐ పర్చేజ్ ప్రాపర్టీ అట్ హైదరాబాద్. అది ఆల్రెడీ డిస్ట్రిక్ట్ కోర్ట్ లో ల్యాండ్ గ్రాబింగ్ కేసు గెలిచాను సార్ 2018 లో. నాకు పొజిషన్ ఇచ్చాడు ఆర్టీఓ. ఇచ్చిన తర్వాత రీసెంట్ గా వాళ్ళు ఏం చేశారు, వేరే సర్వే నెంబర్ వాళ్ళు కేసు ఓడిపోయిన వాళ్ళు మళ్ళీ 2 సూట్లు వేస్తారు. 2 సూట్ కూడా డిస్మిస్ అయినాయి. ఆ సూట్ వేసిన సంగతి కొత్తగా సూట్ వేసారు సార్. దాంట్లో ఎక్స్ప్రెస్ చేయలేదు.
దాంట్లో యూ ఫైల్ ఎ పిటిషన్ అండ్ ఆర్డర్ 7, Rule 10 and 11 for rejection of the plaint, saying that filed against the dead person or the previous previous judgment passed operates as res judicata.
అవును. అది సో దానికోసం ఇప్పుడు ఒక డిఫెండెంట్ నెంబర్ 2 చనిపోయాడు సార్. చనిపోయిన వ్యక్తి తోటి మొత్తం సూట్ వేసి డిస్మిస్ అవుతుంది సార్.
Naturally.
Sir. I am the D1, sir. I am the D1. D2 died, sir.
Whatever it is, if you are D1, then you can file a petition under Order 14, Rule 5 to decide it as a preliminary issue, whether the suit is maintainable or not.
Okay. Okay, thank you, sir.
Right, sir.
Sir, ఇప్పుడు ఎర్లియర్ సూట్ ఫైల్ చేసినట్టు ఈ ప్రెస్ సూట్ లో చెప్పకపోతున్నా కూడా
అది కూడా సపరేషన్ ఆఫ్ ఫ్యాక్ట్స్.
సపరేషన్ ఆఫ్ ఫ్యాక్ట్ మనం ఒక కాలం రాస్తాం కదా సార్. ఇది
డిక్లరేషన్ ఇస్తారు.
yes.
అది ఇవ్వకపోతే అది సూట్ నిలవదండి.
Okay.
Right, sir. And better take certified copies and file it. You can substantiate it.
Sir, thank you.
Okay, can we conclude the class? Sir, okay, you announce saying it, this will be continued revision of important topics in CP.
Let's conclude the class for today. See you tomorrow again.
The announce is better, sir.